Thank you very much for staying with us. Now, the Senzo Meyiwa murder trial continues at the High Court in Pretoria. Cross-examination of Meyiwa's close friend Tumelo Madlala continues. Now, yesterday, Madlala said he recognized one of the men in the dock as one of the intruders. Madlala was in the house when Meyiwa was shot dead in October of 2014. For more analysis on this, we're joined by Mpumelelo Zikalala, who's a legal expert from Zikalala Attorneys. Mpumelelo, as always, good morning and thank you for your time. Another interesting start yesterday. We established that Advocate Defu, who remains on a watching brief for Senzo Meyiwa, had delayed the start of proceedings because he was insisting on seeing the judge along with the three lawyers. Now, Advocate Mshololo insisted that he should have liaised with the registrar instead. So I thought it fitting today to perhaps discuss the rights and limitations of counsel on a watching brief. What are they?
It basically means, yes, you are able to be inside the proceedings but don't sit at the front. This is only in certain circumstances in which you'll be able to do so. Because if you sit at the front where they are sitting, or where all the legal practitioners are sitting, you are then privy to certain documents which are going to be passed around, certain discussions which are going to take place, and they're certainly not where your watching brief sort of instruction should start or should contain. So you're sitting within the gallery, you are allowed to go and ask questions to the prosecution, go and ask questions to the defense, but you're not really part of those proceedings in terms of you making certain submissions to the court, because you are not, your client is not basically on the stands, or they may be an interested party, but they don't form a part and parcel of the proceedings as they are taking place. It's a bit complicated when it comes to advocates, because if you're an advocate, you get instructions from your attorney, and then on that basis, you are then represent that particular client or the client in which you're going to stand under watching brief for. So I would have expected that the attorney's briefing advocate, therefore, would have contacted the registrar, contacted all the other parties and said to them, we want to introduce and place ourselves on record that you are on watching brief. Can you please give us an opportunity to do that? It is done in a formal manner, contacting the registrar, and not in a manner in which you are seeking to do. Let's remember, we are not fighting each other, or it's not supposed to be a hard process. It's supposed to be easy, seamless, but governed by one thing, which is respect of the processes that must be followed. If you are then allowed to sit in, then you could do that perfectly without any issues. Let's remember, I think it's Advocate Nell who's also on a watching brief. He's always there. He does not rope, he does not sit in the, but he participates in the proceedings as they are. Or maybe let's take a step back. What are you doing as a watching brief? You're simply there to ensure that the law has been complied, so that in instances where there's been contravention of the law, in this case our Constitution and the Criminal Procedure Act, you are able to advise your clients, and you are then able to take appropriate actions after the proceedings have ended.
No, it is important to note, actually, that Nell continues to be on a watch and brief, very inconspicuous, only engaging the media perhaps after or before proceedings. But let's move now to the issue of the doc identification. We had spoken yesterday that Advocate Baloyi had in fact prepared heads, but it seemed that the council felt there was no need to do that. In fact, Titi Tobane rose and said that it doesn't matter anymore. The state has a right to ask any question, and they equally then have a right to object, after which the court will make the ruling. What did you make of that decision by all of them?
I think they knew that they don't want to delay this matter anymore in terms of the trial within a trial type of proceedings. Anyway, once evidence has been given, you have a right to attack it during cross-examination. And the principles are quite clear when it comes to doc identification. Yes, even though it can be allowed, but it is something which, for lack of a better word, may be frowned upon, or should not attach any particular weight or any heavier weight when it comes to the presiding officer being convinced that this is the person that has been identified. Especially if you are going to highlight as a defense that, let's look at how the investigative officers have handled this matter. They've had ample time in order to bring this particular accused to be identified in a proper identity parade that could have been governed by the principles of the Criminal Procedure Act. They failed to do that. Rather, they've opted to go the route of doc identification, which should not attach any weight. So that's exactly the stance which must be taken by the court, by saying that, yes, we may have done so, but you're not going to attach any weight to it, and it's certainly not going to sway us into thinking that this particular individual is the real perpetrator. What can sway us is independent evidence which come from expert witnesses, for example, your fingerprints, your cell phone records, if they are, and any other eyewitness who are going to say, yes, this is what I saw, there's DNA which links this particular individual and places them on the crime scene, only then can be accepted by the presiding officers as a conclusive proof that this is the individual that you are referring to.
When we speak about the weight placed on that particular evidence, yesterday we saw how even after the agreement by all three, we had Advocate Baloyi now belaboring the point that there needs to be a distinction here between the issue of admissibility and the weight placed with the weight placed on the evidence. Why was there that conflation or that issue all throughout?
Remember that in order for the evidence to be then weighed, it must be admitted first. So any evidence which is inadmissible, maybe due to its contravention with the Constitution, it wasn't obtained in a proper manner, should not be admitted at all. So it's going to be as if the court is turning a blind eye to the evidence being there, even though it has been presented. And the court cannot refer to it in making distinctions or looking at the merits of the particular matter. So the admissibility is the first part of the hurdle. And then the second part is the probability or the weight which you then attach to that part of the evidence. So in this case, they were saying, yes, we can admit this particular part of the evidence to be part of the report, saying that, yes, the third witness stood up and said, I recognize this particular individual who's in the dock. But when it comes to the weight that the court must attach, that's where we are going to attach it the most, and then say to the court, don't accept or don't attach too much weight on this evidence. Because, or due to the manner in which it was obtained, due to the ample opportunities that were there, we highly feel that our client was then a sitting duck, for lack of a better word, within that particular proceedings, because they are the ones who are being branded or that have been identified as the accused. So it's easy for someone not to independently think and then simply say, yes, this is the person who was there, or be easily influenced due to that person being the only individuals who are sitting at the dock at that particular point in time.
Now, when we look at this case broadly, it's been characterized by a lot of speculation and conjecture. But yesterday, some believed that the defense's case was starting to take shape, where he shared the motive, or at least gave meat to that version that Kelly may have shot Senzo Meyiwa accidentally. Did you get a sense of where he was heading with his line of questioning yesterday around perhaps some sort of a love affair that was taking place between Meyiwa and Kelly's sister, and then even touching on his character at some point, something that the judge took exception to?
I think what they're doing is they're then saying, even though I'm not placing the version of my client, because I think that the defense would be my client was not even there, but your motive for lying or misleading this particular court is that you're protecting certain individuals. And the reason why you're protecting that particular individual is due to financial compensation that you've received or other gratification that you've also received pertaining to this whole proceeding. So at the end of the day, there's someone which you're protecting, and the way in which you're protecting them in is by lying or covering up for them. Tell us the truth so that we're able to get down to the bottom of this particular matter, and we're able to bring the real perpetrators to sit in that particular accused box. So what he was doing was testing and putting the versions in which all should be done in cross-examination, and saying to him, can you then accept or deny this particular points that you are saying? One would expect that in reading the docket or the two dockets, there would have been either evidence in which they would have found which would later corroborate what they are saying, or there are certain witnesses who are going to be brought in, and that particular witness that will be able to corroborate whatever versions that they are putting to this current witness. So that at the end of the day, when the presiding officer is assessing the evidence in its entirety, they're then able to say, oh, this is why they were asking these particular questions, and this particular answer ties in with the version of the defense. Let me find of the defense so that at the end of the day, they are let free. So it's all the putting in the pieces of the puzzles at different intervals. However, when you look at the whole of the complete picture, they must be able to talk to each other. This is what I always say. There is no question in cross-examination which is lesser important or which is a minor question. All questions are important and ought to be answered and be analyzed in a proper manner. So let's not play down the versions which were stated in yesterday. Evidence may come in at a later stage that may show credence to it.
And I like that you say that, because it seems there is some sort of method to what some might assume is madness. Because just the question of saying to Tumelo that you're constantly being given money, you were given money to come, you were given money to go back. So clearly starting to paint a picture of a gentleman that might be willing to take money because of a maybe difficult financial position. So anything is possible. It may have seemed silly at the time to some, but when you start to put the pieces together, you almost can see where he's headed with this particular line of questioning. Mr. Zikalala, it's been a pleasure talking to you today. As always, enjoy your weekend. That's Mpumelelo Zikalala, legal expert from Zikalala Attorney.